Good evening, all of you. Thank you very much for joining and welcome Dr. Yatin for today's session. So he'll be discussing about the AI and IPR that he is having expertise in that. So he's currently working as an assistant professor at Symbiosis Law School, Noida. Before that, he was also faculty at SRM University, Sonipat, and then also faculty coordinator at Center for Law and Technology, where he developed, and then this AI-related curriculums also, and then various research, mentoring students, and then organize various academic activities also. So he has done PhD from the Department of Law, Punjab University, and the alumni of RGNLU Punjab, that's Rajiv Gandhi National University of Law at Patiala. And his research work centered around the governance and ethical implication of AI technology. His work includes studies on responsible AI, impact assessment mechanism, comparative analysis of data privacy regulation across different jurisdictions, and the challenges posed by the generative AI in the creative landscape, particularly its implication of intellectual property laws. Uh, Dr. Yatin is also the founder of Just AI, is an educational platform dedicated to promoting responsible AI practices and keeping the community informed about the evolving regulations globally. Dr. Yatin's expertise in dedication make him a leading figure in the field of AI ethics governance, continually contributing in the development of responsible AI practices. So, this brief introduction, I will be on behalf of organizing committee. We welcome Dr. Yatin and request you to proceed with the session. Over to you.
Thanks for a lovely introduction, Dr. Kalpesh. I hope PPT is visible and I'm audible to everyone.
नहीं पीपीटी अभी नहीं दिख रहा है, नॉट विजिबल.
It is not visible. Okay. Uh, Now,
नहीं, नॉट येट हियर.
not yet. Okay, wait. Yes, now is it visible?
Not yet. It's showing you have started sharing screen, but not visible.
Okay,
Yeah, now it's fine. Yeah.
great. So, it is truly an honor to be part of this esteemed capacity building program uh, that is on data privacy and artificial intelligence. I would like to congratulate the organizers, Sambhavya Federation of Transformation and Pro Bono India, to organize such a relevant and timely initiative. And I would like to extend a special thanks to Dr. Kalpesh for giving me this opportunity and for inviting me uh, in this program as an expert and to give me such a contemporary topic uh, for delivering the session, that is artificial intelligence and intellectual property rights. So, as we all know that AI has become integral part of our life, and it is being integrated in every sector, whether it is education, whether it is the legal sector, whether it is e-commerce. Everywhere we are witnessing AI in some or the other form. Now, because of this rapid integration, we are facing various kinds of ethical, social, and legal issues. And because of such issues, there is call for transformation or there is call for some modification in the existing legal systems. Whether it is a constitutional law when we are talking about human rights, algorithms, and AI systems are discriminating uh, over gender, over entity, over our identity, right? Or whether if you talk about the criminal liability, determining the criminal liability of the wrongful activities committed by AI systems, or whether determining the civil liability or compensation to be awarded to the victims of the AI systems, every corner of our legal system, most of you can say part of our legal system is struggling with this kind of transformation and this modification. And IPR is not an exception to it. Uh, IPR, in particularly, if you talk about IPR, we are facing uh, two type of prominent issues, or the legal scholars, or judges, or the academicians, even the lawyers, they are trying to get an answer for these two prominent legal queries, which you can see on the screen. First legal inquiry, which I'll be talking about, is whether AI generated work shall be given protection under the existing IP laws or not. Okay, and the second prominent legal inquiry, which we'll be discussing, is whether training AI models on protected works, or the works which belong to other people, other entities, if you are training the AI models on that, whether this amounts to copyright infringement or not. So these will be the two prominent legal queries which we'll try to find out, on which we'll try to find out the answers. Okay, so how we'll do it? First, we will understand the generative AI system. What is generative AI? And what are the prominent generative AI applications are currently in use, and in what different domains generative AI tools and systems are being utilized. Then we'll come on to our first inquiry, that is whether AI generated work shall be given copyright protection under the IP law or not. We'll try to answer this by analyzing the case study, famous case studies on Raghav and Debus AI systems. What decisions have been taken by the copyright offices and the courts in various jurisdictions in India as well as in abroad with respect to this particular question, with respect to this particular inquiry. Then we'll come on to our second legal query under the IPR and intersection of AI, that is whether training AI models over the protected works amounts to copyright infringement or not. For answering this particular query, I'll be discussing the ongoing cases, the current cases, that is the ANI versus OpenAI. This is the recent case which is currently going on in Delhi High Court. And I'll be also discussing about the case between New York Times and OpenAI. So these are the two relevant or high profile cases which will help us in answering the second legal query. Okay, at the last, I'll be also talking about the way forward, or the suggestions which could be incorporated by legal systems to basically address these two prominent issues. So let us begin with generative AI. What is generative AI? It is an advanced type of AI technology or advanced type of AI system, which basically has the capability, the system has the capability to create content, to generate content. And this content can be in the form of text, in the form of images, in the form of videos or music. And how these models work? These models are basically trained on vast amount of data, and because of such training, they learn from the data itself, learn from the training data, and they basically become capable of generating the content, generating the new content based on the prompts or based on the inputs given by a particular user to these AI systems. Now, why this particular technology, generative AI, is different from traditional AI technology? The reason is that because the traditional AI systems were limited to perform specific tasks, and they were they were designed to perform specific tasks based on the predetermined instructions. Okay, but these generative AI system has the capability to learn from the vast data and to generate the outputs which are not even predetermined by the manufacturer or the designer itself. Because of this reason, because of this particular ability, we are seeing more challenges and more issues with respect to generative AI systems. So generative AI system has two important components, that the utilization of algorithmic setup, utilization of traditional AI technology, and the ability to create content. Okay. So how they create content, they learn from the data, they recognize the patterns, and they take the inputs from the users, and they are able to create the content in the various forms. And because of their ability, these kind of systems are now being integrated in different kind of setups. Okay, if you will talk about the academic setup, most of our students are using AI, chat GPT, on or large language models to create their assignments, and they are submitting their assignment using these AI systems. If you talk about marketing, uh, you can create beautiful uh, creatives, or beautiful, you can write, you can say, interesting content for your social media platforms for marketing purpose. And uh, because of such integration, and because of you can say such ability of generative AI systems, we are facing multiple issues, and specifically under the domain of creativity and under the domain of intellectual property rights. Now let us look into the prominent or the famous generative AI systems which are being utilized in various domains. You can see the different domains or different areas on the slide itself. So first domain is the text generation. So under this particular category, large language models, generative AI models, which are also known as large language models, they are being used for text generation. And we all know about the famous model from OpenAI, ChatGPT. We all might be using it. And the most recent large language model, which has gained popularity very, you can say, rapidly, that is DeepSeek, a large language model from the Chinese company. So this type of model works upon NLP, that is natural language processing, and they have the capability to generate human-like text and to give answer to your questions. You can write essays, you can draft your emails using such models. Okay, and even if you want to write a code, and if you are not a technical person, and if you want to write a code for developing a software or for developing a website, even a non-technical person can utilize this particular model for the scientific purposes or technical purposes. As you can see, this is the time because of the launch of OpenAI's model, ChatGPT model, we started, you can say, we started feeling artificial intelligence. It was there earlier also. If you talk about your Gmail, they have been utilizing artificial intelligence to segregate your emails into different categories. That this particular email will go into spam folder, this email will go into your inbox, this will go into the updates. So that was there even in the Google platform. The algorithms were there earlier, but we started feeling the real feeling of AI basically came when we came across with OpenAI's ChatGPT model. So this model basically gained popularity very rapidly. If we talk about ChatGPT, in just 5 days, uh, OpenAI ChatGPT model had 1 million users, and currently around more than 180 million users are there over OpenAI. And if you talk about DeepSeek, DeepSeek basically uh, had crossed this particular benchmark of 1 million users in 10 days. But if you talk about other social media platforms like Facebook and Instagram, they achieved 1 million users in almost a time period of 1 month or more than that. So you can see the popularity and rapid integration of the AI models, specifically large language models. So I've also mentioned a few others, large language models for your reference. Bhashini is one of the AI model created by Indian government, created by the MITI. And this particular model has the capability or ability to translate the text into 22 different Indian languages. Okay, then we have Bard, a model from Google, which is an LLM model. Then we have Llama Palm 2 model from Meta. We have Claude AI, and we have Turing NLG. These are the examples of large language models which are uh, in use currently. Second kind of category in which generative AI models are being used is the image generation. Dell E again from the big tech in the field of AI, that is OpenAI. DAL E is the another model which generative AI model which is being used for creating images. You just have to give the prompt in the form of text. You just have to give the input to this AI system in the form of text, and it can create the images for you. But now, even ChatGPT has this particular feature. OpenAI ChatGPT has this particular feature. You can create images using that also. So, DAL-E has active users of around 1.5 million. Okay, and around 2 million images are produced per day using this image generation generative AI model. Another examples of a generative AI model which can generate images are Midjourney, Clearview, Stable Diffusion. All these companies, all these AI systems are currently facing some or other kind of uh, matters, legal matters in the courts in various jurisdiction in various countries. Next model or next domain is video generation. In video is the popular generative AI model for this particular purpose. Again, by simply giving the prompt, you can create a video. Okay, and next kind of domain which we have in which generative AI model is being used is for music generation. So again, you can give two or three songs to this particular model. Avia is the name of the model which is being used in for music generation. How this model works, you can give two or three songs to this AI system, and you can ask to compose altogether a new song using this model. Again, such kind of models are also facing multiple legal issues, and the legal matters are going on against music generation models also in various jurisdictions. So, apart from the generative AI models having specific capability or working for a specific domain, we also have multi-model AI system, multi-model generative AI systems, which has the capacity to work in different domains uh, simultaneously. Okay, if you talk about GPT for Omni or for O model, now Omni, why they have used the term Omni? Omni signifies presence everywhere. Now GPT for Omni model has the capability to understand or to take inputs in the form of texts, in the form of images, in the form of audio, and again they can give the outputs in multiple domains, in multiple models. Okay, you can get the output in the form of text also, you can get the output in the form of images, in the form of audios. Similar model, multi-model, is also launched by Google DeepMind, that is named as Gemini Ultra 1.5. So these two models are the multi-model generative AI models, which can work across in different domains at the same time. Now let us come over to our first legal query, which the world is facing, which uh, the courts are facing currently, that is whether AI generated work shall be given copyright protection or shall be given protection under the IPR laws or IP laws or not. So before coming to the conclusion or before addressing this legal query, let us first uh, discuss a case study from India itself. So this case study is about Raghav, which is an AI tool, which is an AI system which has the capability to generate the images. So this system was developed by Mr. Ankit Sahani, who is an artist also, multidisciplinary artist also, and an IP lawyer. And he eventually became the first person in India to get the copyright protection for AI generated work in year 2020. So what he does, he basically clicked a photograph from his camera or his phone. You can see the photograph clicked by him on the left side of the screen. And he picked an image uh, of a painting from a famous artist, from famous Dutch painter, that is Van Gogh. And the name of the painting was The Starry Night. He combined these two paintings and gave a prompt to Raghav to basically use these two images, his own clicked image and the Starry Night uh, painting image. And he asked the Raghav to generate a new image by combining these two images. And this is the final outcome which he got. And he named this particular image as the Suryast. Now, for this particular image which he generated from the Raghav, for this particular image, he filed an application before the Copyright Office of India, and he filed two applications basically. In first application, he asked for granting the copyright protection for the Suryast image to the Raghav itself, that is the AI tool, AI system. He claimed uh, for granting copyright protection to Raghav itself, that is the AI system. And in the second application, he asked for granting copyright protection uh, to the Raghav and treating to himself. He should be treated as the first author of this particular image, and he requested to treat AI system Raghav as the co-author of the image. Okay, so first application in which he requested for granting Raghav, uh, treating Raghav as the copyright owner and as the sole author of the Surya's image. This particular application was rejected by the Copyright Office. Although the second application in which Raghav was the main author and AI has to be treated as the co-author or the second author, this particular application was accepted. You can see the screenshot here, and you can see the details of the registration. This particular work was given copyright protection under the class of artistic work, and uh, AI was ultimately treated as the co-author, and Raga was treated as the first author for the Surya's painting. But later on, he was granted this particular copyright protection in August 2021, around this month only. But later, Copyright Office in India realized its mistake, and in December 2021 only, they asked Ankit Sani to basically withdraw this copyright application, and ultimately this award of copyright protection to AI as the co-author was rejected by Indian Copyright Office also. Similarly, Ankit Sani made application for copyright protection for Suryas in various jurisdictions. In USA also he applied for the copyright protection, but in USA again he was rejected. And what was the ground? The ground was common in India also and USA also. The application was rejected on the ground that only existing IP laws, existing copyright laws only treat human as the author of the artistic works or literary works or copyright works. The AI or a machine cannot be treated as the author. So on this particular contention, India as well as US Copyright Office rejected the application. But when it comes to Canada, he also filed the same application in Canada. Canada basically granted copyright protection over this particular work, and where AI system Raghav was treated as the co-author of the image Suryas. So you can see the confusion, you can see the difference in the decision coming from different jurisdictions uh, over the same issue, over the same legal issue under the IP laws. Let us discuss one more case of USA, that is Thaler versus Perlmutter. This is the case of 2023. So this case involves uh, the again involves a AI generated image, copyright protection regarding AI generated image. So Dr. Stephen Thaler, who is an American scientist, he developed an AI system and he named that system as Creativity Machine. And this system has the capability again to generate visual artwork. And he created an image using Creativity Machine, and he named that image a recent entrance to the paradise. Again, same thing happened here. Dr. Stephen Thaler filed a copyright registration application for this artwork in USA, and he basically uh, in his application he asked to treat AI system as the sole author and himself as the owner of the copyrighted work. So you can see the difference in the claim which was made by Ankit Sani and the Dr. Stephen Thaler. Okay, so again, US Copyright Office denied this application, and same reasoning, same rationality was given by the US Copyright Office in this case also, and they stated that the existing IP laws only treat human as the author, not uh, any AI system or machine. These kind of systems or machines are not eligible for awarding copyright protection under the existing IP laws or copyright laws of USA. Thaler then again challenged this decision in the US District Court. He challenged the decision of the US Copyright Office in the District Court, but US District Court supported the decision of the US Copyright Office, and they affirmed that the human authorship is the fundamental requirement under the Copyright Act. So Dr. Thaler, apart from uh, the copyright work, apart from filing the copyright application, and apart from creating an AI system which can generate images, they also created an AI system known as Davis. And this particular Davis has the capability to give suggestions for inventions. Okay, so now we are shifting from the domain of area of copyright to the area of patents. Now, with the help of DEBUS, which is an AI system, uh, Dr. Thaler basically created two inventions. First was neural flame, and another was the food container. What was the neural flame? It is a kind of a special emergency light which blinks in the dark in a unique way, and which is very eye catching, and which could be helpful for for avoiding any kind of accidents, especially in the night time. And second invention, which was developed with the help of Davis, was the food container, which was a kind of a lunch box or a storage box where you can store the food for a longer period of time, and which also maintains the temperature so that food can be preserved for a longer period of time. So these were the two important inventions which were created by Dr. Stephen Thaler with the support of the AI system Davis. Again, for these inventions, Dr. Thaler uh, filed patent applications in different jurisdictions. But in most of the jurisdictions, the patent application was rejected. The DABUS was not uh, given the patent protection, was not treated as the inventor. But there are few uh, jurisdictions where Dr. Thaler managed to get the get the patent protection for the inventions done by the Davis. As you can see in the UK Intellectual Property Right Office and the High Court of England and Wales rejected the patent application. And again, the same reason was given that only a natural person or a human can be the inventor. Again, USA Patent and Trademark Office rejected this idea, this kind of applications, and gave the same reasoning that patent law only recognize humans as the inventor, not an AI system. Canada, although when we talked about Sani's case, they granted copyright protection to the Ankit Sahni regarding the image generated by AI. But when it came to patent, they rejected this particular application in Canada. And Europe also rejected the patent application, but most recently in 2024, December only, Germany granted the patent to Dr. Thaler. But we have to see that the patent was given to Dr. Thaler, not the Davis. So Germany took one step further. Germany recognized the work generated by AI, and they recognize that such works can be given protection under the IP laws, but ultimately the owner of such work can be human. But if you will talk about other jurisdiction, they simply denied to recognize such works. Okay, but Germany accepted this particular application and recognized the AI generated work under the intellectual property law. But ultimately, they gave patent to Dr. Thaler only, not an AI system. So you can see this is the position currently going on worldwide with respect to this particular query, that whether AI generated work shall be given copyright protection or not. So courts are confused, copyright offices are confused. You can see different decisions coming from different jurisdictions. Even South Africa gave the decision in favor of the Dr. Thaler, and they recognized such work. Now let us see position in China. Uh, with respect to China, I'll discuss two important cases. First case is Shenzhen Tencent versus Shanghai Yingsun. Another case is Li versus Liu. So first case is of around is of 2019 case, and this case talks about the large language model, involves a large language model, a generative AI model through which you can generate the text. So what happened in this case? Tencent, the plaintiff, used a large language model to write an article, to create an article with respect to a financial domain. Okay, so he created an article using an AI system, and what happened? Another website copied that particular article and published that article on their website without the permission of the Tencent. And the Tencent basically filed a copyright infringement lawsuit against that website. What was the outcome of the Chinese court here? The court granted the protection, recognized the ownership over the AI generated article of the Tencent, and they asked to pay compensation to the website for this particular infringement. So now, because of this particular judgment, China became one of the first jurisdiction to recognize copyright uh, protection to AI generated work or in context of AI generated work. Another case is with reference to the tool AI system through which you can generate the image. And this is one of the famous tool which I talked about in earlier slides also. The name of the tool AI system is the Stable Diffusion. So with the help of Stable Diffusion, you can create an image, you can generate an image by simply texting it or giving a prompt to this AI system. So Mr. Lee, who was the plaintiff in this particular case, Mr. Lee basically generated an image with the help of stable diffusion, and he gave some kind of prompts and some kind of inputs to the stable diffusion and was able to generate the image. So he published the this image which was generated with the help of stable diffusion. He published that image on his social media platform, uh, which is similar to Twitter in China. He published that image there. But Miss Liu used the same image in her article. Okay, and she published this article on the other platform. So Mr. Lee basically came to know about this particular act of Miss Liu, and that she has used the image generated by him without his permission, and ultimately Mr. Lee filed a copyright infringement case against Miss Liu. So again, same thing happened in this judgment also, in this legal matter also. Beijing Internet Code recognized the copyright protection, and they extend this copyright protection over to AI generated work. And Miss Liu was asked to uh, give appropriate compensation to Mr. Lee. So this is the position in China. China is recognizing the AI generated work and extending the copyright or IP protection over the AI generated works, and even not even recognizing and even awarding the compensation when such copyright violation is being done. So let us now come to the legal query. Let us now try to find out the answer of the first legal query. Now, to answer this particular query, we will go through uh, four different steps. Uh, I would say it would be a systematic, you can say, investigation into this particular inquiry. So, in the first step, we will first primarily try to find out whether Indian IP laws recognize such works, AI generated works under the legal system, under the existing IP laws or not, whether India recognize AI generated works or not. Okay, then we will look into that if yes, our existing laws may recognize AI generated works if the interpretation of the relevant provisions of the Copyright Act is done in such a manner. If we find that yes, our laws do recognize or may recognize such works, we will try to find out the answer with respect to uh, the creativity and originality. We'll try to find out whether the outputs generated by AI amounts to some sort of creativity or originality or not. Because this is one of the most significant element of awarding any kind of copyright protection to any kind of work. Because if the work would not be treated as a creative, or if work is not original, the copyright application will be rejected on the very face of it. So this is the most important element. We'll discuss about this. If uh, we find out that yes, AI generated work amounts to some creativity or it is some kind of original work, then we will jump on to the next step, that is to find out that who shall be given the ownership. If it is a creative work, if it is an original work, then who should be given ownership of such work? Whether the AI tool itself, or whether the prompt giver or the user or the person who has given the input or instruction to the AI system, or whether the designer of the AI tool. Okay, let us take the example of ChatGPT. So, whether ChatGPT shall be given the ownership of the content or of the article generated from it, or whether the user who is prompting or giving instructions to it, or uh, whether the designer of the tool, that is the OpenAI, the company who has designed this particular tool, shall be given the ownership of such AI generated works. And at the last step, we will discuss what kind of modification, what kind of amendments are required under our existing laws to basically adjust, or you can say to recognize AI generated works. Okay, so this will be the flow. These will be the steps which we'll be following to address this particular query. So first step, whether Indian IP law recognize AI generated work or not. Uh, the relevant section which will be applicable to solve this question is section 13 of the Copyright Act 1957, which says that the copyright protection extends to the literary works, dramatic works, musical works, artistic works, and cinematic graphic films and sound recordings. Now, if you will talk about the section 13, there is no mention, no specific mention about AI generated works in the section as well as in the whole act. Okay, but let us discuss one more section of the Copyright Act, that is the section 2D of the act, which gives the definition of the author itself. Okay, so as per section 2D of the act, author means that any person in relation to a literary or dramatic work, the author of that particular work, in relation to a music work, the composer, in relation to an artistic work other than a photograph, the artist itself, in relation to a photograph, the person taking the photograph itself will be treated as the author. In relation to a cinematograph film or sound recording, the producer, and the sixth clause of section 2D says that in relation to any literary, dramatic, music or artistic work which is computer generated, the person who causes the work to be created will be treated as the author. So they have not used the word AI generated work under the act, but what they have used the term computer generated work. Now, the question arises whether this particular term computer generated work includes or covers AI generated work or not. Again, computer generated work term is not defined anywhere under the act, but if you will go into the technicality, okay, and if you will give wider interpretation to this particular term, the AI generated work can come under the purview of this particular term. Why? Because the computer generated works are basically created or are produced with the help of softwares which work upon some set of instructions or some set of programs which are designed by the creator of the software itself. In the similar manner, AI systems also work upon the all algorithm and set of instructions. So, if you will extend the meaning of the softwares and give a wider interpretation to the term software and computer generated works, AI generated work can also come under the category or come under the purview of computer generated. So, with this interpretation, I would come to this conclusion that yes, Indian IP law, specifically Copyright Act, covers copyright protection over the AI generated works also. We do not have any kind of relevant judgment with respect to the interpretation of the computer generated work covering AI generated works. We do not have any kind of judgment on that. But on the basis of technicality, on the basis of logical reasoning, we can take this interpretation. Now, we have answered, we have completed the first step. Yes, that yes, our Copyright Act basically covers this particular area that covers the protection over AI generated work. Now, the next step would be that who can be given the authorship of the AI generated works. Whether the AI tool itself, we have the three options basically. Whether the AI tool itself shall be given, ChatGPT shall be given, or whether the designer of the tool, that is the OpenAI, shall be given, or whether the person who gave the prompt, or that is the user who is using the ChatGPT. So section 2D4, which we have just discussed, it says that the person who causes, you can see on the screen, that the person who causes the work to be created shall be given the copyright protection, shall be treated as the author of the computer generated works. So, with the help of this particular provision, we can come over to the conclusion that the person who is giving the prompt, that is the user of the AI system or the AI tool, can be considered as the author. Okay. And why not AI tool itself? Because Indian laws uh, also considers human as the sole author and not the machines or AI tools. And now we are left with the OpenAI and the user. Okay, that is the designer of the AI tool itself and the prompter or the user. So as per the section 2 clause 6, the outcome which we get is that the prompter, that the user can be treated as the owner of the AI generated work. Okay, because it is the prompt giver who is ultimately causing the work to be generated when it comes to the AI systems. Now coming on to the third step, that is whether the outputs generated by AI tools are original or not, whether it amounts to creativity or not. So with respect to this particular uh, query, this particular question, why answering this question is important? Because as I mentioned earlier, originality and creativity is one of the most significant element which Copyright Office looks into the application, whether this particular work is original or creative or not. Then only they accept the application and they grant copyright protection to it. So there are two important elements with respect to uh, treating a particular work as original or creativity. First, it should be original and it should come from the author itself. And second important element is that there should be some involvement of skill and judgment on the part of the author for creating the particular work for which he or she is claiming copyright protection. Okay, so remember these two uh, essentials. That is, the work should be original and it should come from author. And second, there must be utilization of some skill and judgment on the part of the author to treat the work as creative or original. Okay, so same principle was given in Eastern Book Company versus DB Modak case, and this case was between the DB Modak and the SSC online, Supreme Court cases online. So what DB Modak did, DB Modak launched a software which contained a copies from the judgments which were published by the SSC, and basically EBC filed a complaint copyright suit uh, against DB Modak, claiming that uh, DB Modak has developed a software and trained the software on the work which was the copyrighted work of the EBC. What happened? EBC basically uh, created the their work, or they basically published the judgments by simply scrapping those judgments from the SSC, and they uh, did some additions. Okay, they added some paragraphs, the numbers, and they changed the format of the judgments, and they claim that they have uh, put some effort, they have put some skill and judgment over formatting the original judgments from the SSC, and therefore it is their copyrighted work. So the judgment from the court said that yes, uh, although the judgment was published, original judgment was published in SSC online, but EBC basically made some adjustments to it, and they deployed some kind of skill, and you can say there was involvement of some human judgment, and there was some creativity on the part of EBC. So EBC has the copyright over their work, and DB Modak cannot say that EBC has taken the work of the SCCA, which is available in the public domain. So ultimately, what I'm trying to uh, uh, make you understand from this judgment is that this judgment says that even the small amount of skill and judgment, human skill and judgment is involved in the creation of a work, that will get a copyright protection. Same principle can be applied in the case of the AI generated works. So you have to understand that if a prompt giver is applying his skill or judgment by writing the prompts in effective way and to get a specific outcome. So such type of activity, that is the prompt given, can be treated as a skill and can be treated as an activity which involves some kind of human judgment in it, or some kind of creativity or originality in it. Why I'm saying that prompt giving is a skill? Because you can see that there are number of courses, number of uh, programs, number of educational learning programs are being organized or being launched by various educational institutions as well as universities. Uh, those who are only basically uh, making people learn the skill of prompt engineering. So it is an established skill now, and you can see the various courses on the screen itself. There are courses available for engineers also. Even there are courses available for lawyers also, how they can use AI systems effectively uh, to create legal content or to use AI systems in the legal domain. And you on the screen you can see the salaries of the prompt engineers also. The average salary in India of prompt engineers ranges around 34 lakhs. So by this logical interpretation, it is uh, you can say established that prompt engineering is a skill because universities are giving courses over it, and the people who are trained or who are expert in this particular area, they are well paid in the industry. So ultimately, we have answered all the three or four important questions that yes, our Indian law recognizes AI generated work through the interpretation of computer generated work, and uh, it is original or a creative work because there is involvement of some skill and judgment on the part of the prompt giver, because uh, giving prompt and giving good instructions to an AI system to get effective result is a kind of a skill. And again, we also dealt with the question that who can be given the copyright protection. So it is the giver or the user of the AI system who can be given the copyright protection under the existing IP laws. Similar contention had been made by WIPO as well as the US Copyright Office with respect to the AI generated works. Recently, in January 2025 only, US Copyright Office came up with a report uh, on AI generated work. And in this particular report, US Copyright Office addressed this particular issue. And you can see on the screen that they clarified that AI generated works can be recognized uh, as a work which can be given copyright protection or IP protection under the existing law, but there are few conditions. The ownership will be given to the human author only, not the AI system. Okay, AI system cannot be treated as a creator, okay, or the inventor or the author of a copyright work. Okay, even they mention that simple prompts, simple instructions will not be enough to avail the copyright protection or IP protection. The prompts should be complex. There should be some involvement of human skill and judgment. The prompts should be of expressive nature and it should come from the human author. So if you are simply writing a prompt or one-liner prompt that create an image uh, of a US president uh, having a cup of a tea with the Russian president. So that particular prompt will not be treated as an expressive prompt. So there must be some kind of input, some kind of skill, some kind of creativity involved in the input or the prompt itself. So simple prompts will not be recognized for giving the copyright protection to the AI generated works. Okay, so this is the most current scenario with respect to the first legal query. So what solution which I would like to recommend with respect to the first legal query, that we should or legal system should recognize AI generated works. Okay, but the works which are totally automated and which has no human skill or judgment on the part of the prompt giver, such works should not be recognized by the legal systems, and ownership shall be given to the human author. But I will add a line in it that besides recognizing human as the author of the AI generated work, there should be a mention in the in the copyright certification itself that this work has been generated by a human with the support of a particular AI system. Okay, so that is the solution. That is the way forward, which I would like to convey with respect to the first query. I think for the second query, we are running out of time. Dr. Kalpesh, what is your say on this? Shall we move on to the second query? Or we can take the questions from the participants.
I think we can take up question from participants.
Okay.
Mm.
Love to.
There are a couple of questions in the chat box. Let me read out. Participant, you can raise your hand also if any questions are there. There is a question from Bhaskar. So in Germany, the application was filed in the name of both Dabus and Dr. Thaler as an applicant. That's a question.
Yes, basically, he filed an application on the name of Davis as the co-author and treating himself, Dr. Stephen, as the author of the copyrighted work. So ultimately, they treated Dr. Stephen as the author of AI-generated work, and Debus, which was an AI system, was not treated as the co-author. So ultimately, they retained on this particular contention that only human can be treated as the sole author, not the AI system.
Sure, sure. Another question, even if a prompt given using a skill and judgment, but if the model which is used is using copyrighted material, can it not be said that output is also copyright violating material?
This particular question will come under our second legal inquiry because of shortage of time. We were not able to discuss that. Yes, there is an issue that if AI systems are trained on the copyrighted works, their outputs will also uh, be violated of copyright infringement of the authors. So ultimately, for addressing this issue, we have to understand how these AI systems are trained. We have to understand the life cycle of the AI systems. So life cycle of the AI system involves various steps. That is the collection and storage of data. For this is the first step. Then training and fine tuning the AI model. Okay, then evaluating the model. So in these all of these steps, we have to see that we are not storing any kind of data which is copyright. We are not training the model which belongs to copyrighted content, and we are evaluating when we are evaluating the performance of such models. We are looking into this particular perspective that these models are not being trained on it. So ultimate solution for this would be that the AI designers, the tech platforms like OpenAI, they can have a licensed agreement with the content creators, and they can award compensation, adequate amount of compensation to the content creators, and they can then use the copyrighted data to train their AI models. So such kind of model will be helpful. I hope I
Okay,
answered.
sure, sure. Okay, another question like what about the patent act? It's all about you talked about copyright. What about the patent elements, patent act?
See, when we talked about a patent, if you will see the legal matters, most of the legal matters are across the copyright only, because ultimately the AI systems which are being designed, their outputs come under the domain of copyrighted works only. You will not see much of the cases apart from the Debus case, which we already discussed, which was with respect to the patent application only. If you talk about ANI versus OpenAI, or if you talk about New York Times versus OpenAI, they all these are the all cases which revolve around the copyrighted works only. But the same contention, same reasoning from coming from the courts and the copyright offices can be applied with respect to patents also. As when it comes to copyright protection, only the human is treated as the author. Similarly, under the patent, only the human shall be treated as the inventor. Plus, what we can do, we can say that inventor is the human, but again, the invention is being done with the support of an AI system. That can be the way forward in patents also. So same reasoning can be applied there.
Sure, sure, sure. Next question, if AI infringe, who will be the liable? The AI user or the AI owner?
AI infringes the copyright. Who should be liable? So ultimately, liability shall primarily arise on the designer of the AI tool itself, because they have trained their AI systems on the copyrighted work without the permission of the content creators and without providing adequate compensation or without availing the license from them. But again, this is the important question, because suppose they have developed an AI system where they have not trained their AI systems on the copyrighted works. But being a user, if you are using an AI system, you copied an article from a website and you gave a prompt to the AI system. Okay, now that AI system learned the copyrighted content because of the user, not because of you. In that particular case, liability can come over to the user also. So it depends the from whom the copyrighted content is being coming as an input or as a training data. That particular activity has to be analyzed. Sir, can we ask the participants to unmute and discuss, because I can see some responses also. Yeah,
Yes, yes.
we can.
Rameshwari, over to you. You raise
Uh,
your hand.
yeah, sir, thank you. So basically, my question is, if the credit is given to the user, then why not the liability?
Yes, that's what I said. No, because we have to see that the copyright content is coming from which entity. If it is coming from user in the term of input, then user shall be held liable. Or if it is coming from the training data in the form of training data of the AI system, which will ultimately be done by the designer of the AI system, then the designer should be held liable. So you have to differentiate. You have to see that copyright content is coming from which particular entity. The user can also be held liable if the content is coming from the user as the input. That would be my say. I hope I answered your question.
Okay, T. Chopra.
So my question is that can like the prompts that say I'm giving to generative AI, can that also be like violated in the sense that say I'm having some idea, I may use generative AI to create some works, but then like Google often, shares the data that we are putting into Google to Google what we want to like search for. So can that like be violated on the part of say like the companies like OpenAI and create infringement issues?
We see you have to understand what is the source of the data on which these models are being trained. So ultimately, if you talk about the cases which I was referring to, that is ANI versus OpenAI or New York Times versus OpenAI, the court asked them that what is the source of the data on which you have trained your AI models, which you have or you trained the Chat GPT model. So they had to provide it the source, and they admitted this particular part, that we are scraping the data from the websites which are available on the Google. And on the most of the websites, if we talk about the websites which are publishing some kind of blog or articles, those websites have the content which are copyright protected. And if uh, the OpenAI is training their AI models through web scraping, through random web scraping, through websites which are available uh, uh, on the Google or on the web domains, then that will amount to copyright violation. So ultimately, they have to keep a check on the data which they are collecting. They have to see whether they are training the data the data which they are collecting is a licensed data or not, or it is a copyrighted data or not, or they have taken adequate permission from the owner of the copyright content. They have to look into this particular fact. So ultimately, it will amount to copyright violation if they are not taking the permission and they are scrapping the data from the Google.
Another question like, second. Okay, another question like, how will it come to know, like, the content that we are using created by the user is original or not? Because we are not aware about whether copyrighted material used to train the model or not.
Yes.
So,
See, there is a requirement, specifically if you talk about EU AI Act or EU regulations. I will try to refer that. There is a requirement that all these designers who are developing AI models, they have to publish AI model cards. So what are AI model cards? AI model cards basically contains the information regarding the AI model itself. That on what kind of data, what are the sources of the data on which their model are being trained. It talks about transparency also, how their AI model works, how they come over to a particular outcome, what kind of set of instructions has been given, what kind of information will be disclosed to the third parties. Suppose if you are giving prompt to Chat GPT, then whether they are learning on their prompts or not, whether their model is learning on your prompts or not. Such kind of transparency information is also mentioned in the AI model card. So in India, we do not have such system as of now. But if you talk about jurisdictions like EU, their AI systems, the designers of the AI system has to give this particular information, has to give AI model cards to the regulatory authorities or the compliance authorities. So from that, reading from AI model card, you can know about such information.
okay, we will take up last question. Mahendra Ralhan, over to you.
Yeah, I think thanks. Sir, this is a good session and too technical also from my perspective. I just question on this. This AI being new in this field of this IPR law and others also. Do you think there are going to be a change in the existing IPR law, considering that the human element is a must in this case and all? As you've seen, couple of cases when it gone for registration, be it in USA, be it in Canada or Germany, whatever it is, then in Indian law also, human involvement is a must. You see some changes are going to happen.
See, ultimately, uh, I would like to quote a order, an executive notification on the part of ministry, Indian ministry of this notification came in 2022. Basically, Rajya Sabha, this question was raised in Rajya Sabha, and Rajya Sabha asked Ministry of Information and Technology to basically answer this query whether any kind of modification is required under the existing IP laws or not. So ministry published this notification. You can find this notification on the website also. They said that our existing law is well equipped to handle these emerging issues, the issues related to AI. But what we have to change is we have to uh, change the interpretation of the existing provisions. As I mentioned, the computer generated works and can be widened. This particular term can be widened to include AI generated works also. And when it comes to the ownership, the author of the computer generated works is treated as the person who created that. In the same way, with respect to AI systems, prompt givers can be treated as the author. So ultimately, there is no requirement of changing the language of the statutes or the copyright enactment. But yes, the interpretation of such terms of or few sections or provisions under the existing IP laws has to be widened to cover the existing or emerging issues associated with the AI technology. No such changes will be required, but yes, it would be easy for the codes if the things are expressly mentioned under the acts, because ultimately currently we do not have any official legal definition of term artificial intelligence anywhere. We do not have the definition of term AI under the IT Act, Information Technology Act, okay, or under the IT rules also, or under the Data Privacy Act. We do not have such definition of term AI under any of the enactment. The definition, more or less, which you can see is under the National Strategy of India 2018, which is not a, you can say, enforceable legal document, which is just a strategy to promote AI technology in various domains. But yes, providing the definition of AI or express mention of the provisions related to the AI will help the courts to give effective judgments. But ultimately, as of now, to deal with such cases without amendments, the widening the interpretation will be enough. That would be my say.
Yeah, I think, sorry, participant, we won't be able to take more questions. So thank you very much, Dr. Yatin, for discuss about the AI and IPR, and especially you did a great comparison because it's not a national thing because we have to compare with what's happening. It's a international level, the aspect that we have to discuss, like what's happening in other country and what we are doing in Indian context. And the first time it's really, I also got insight, that's a computer generated work. It's matter of
Yes.
interpretation. Maybe in near future, High Court or Supreme Court, they do this kind of interpretation, and then
Ultimately, Dr. Kalpesh, the decision is going to come. ANI is the news agency of India, and many of the other entities have also joined ANI in this particular matter against OpenAI. So we'll see the judgment in another 2-3 months. Let us see what court says.
sure, 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 sure. Thank you very much, Dr. Yatin, and the participant for great questions, and look forward to see you in future. Thank you.
Thank you. Thank you.